Welcome to the Only Male Cruz Show, the podcast. I am the only male Cruz. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work. All right. Welcome to the Only Male Cruz Show, the podcast. I am the only male Cruz. All right, y'all. So I guess the block is going to stay hot probably all weekend long. Earlier this morning, Darrell's attorney dropped another motion, a supplemental motion to compel discovery. And the bottom line is, the government, NDIL, they own one. Okay. Let's see. Shout out to April Showers. How you doing? Thanks for pulling up. And y'all be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Shout out to Tiffany only, please. Hey, listen, I appreciate y'all pulling up. I don't plan to keep you long, but I do want to bring this breaking news. What in God's name is the government doing, y'all? That's what I need to understand. And, I want to say this. For everybody who says, no, Kelz deserves those 30 years, put him under the jail, you know what? The government is not playing fair. They are not following the law. They are doing what they want to do and how they want to do it. Okay? And so if the government is so certain that Kelz is guilty and they got him, red-handed, smoking gun, the whole 9 yards, if that's what's up, then why do y'all have to do all this tomfoolery? Okay? So I'm just going to jump right into this motion because this is ridiculous. All right, so Darrell's attorney, as y'all know, it was discussed in the phone call earlier this week about the government, specifically AUSA Kroll, reaching out to Jim DeGrotis through the email. And then during that telephonic hearing, the state was trying to say, oh, yeah, it's good, Judge, because, we're not going to call DeGrotis no way. Come to find out he's been subpoenaed, though. But they said, well, we ain't calling him, so, it's no big deal. But come to find out, Kroll has been having some detailed conversations that she was keeping on the low. So, title of the show today, Boss Baby and the 312 Pied Piper. Here's what's up. Why is the AUSA calling herself, or as you were, why is she calling herself 312 Pied Piper? And why is she calling, allegedly, Minor One Boss Baby? And if this woman is white, I resent the racial overtones with this. Why are you using, it's cool if we call each other that. But if you're white and this it's feeling like a mockery. It's feeling like a mockery. Let me shout out the chat. Melissa Renee, YZF. Thanks for pulling up. Good morning to you as well. Alexis Monet in Living Color TV. What's tea, y'all? Yes, right. Make it make sense. The truth don't need no help. Trina 16. What's up? Lies they tell. What's done in the dark? It is coming to light. And the bottom line, again, is if y'all are about the right government, why are you doing this sneaky crap? Huh? Speak on that. So let me get into this. Darrell's attorney submits this motion. He says, these mysterious, clandestine, and totally inappropriate forms of communication necessitate further investigation into the circumstances surrounding the handling of witnesses in this case by the government counsel and the government agents, and the question of whether witnesses may have been improperly influenced by these individuals. And y'all know in damn near all of the motions, all of the motions, the government has said Kelz and Darrell and June attempted to coerce, induce, entice. But what have you done, government? Because this is essentially what it appears to be that you guys have done. So what's tea? It says here, on August 1st, 2022, the government first disclosed copies of email correspondence between Kroll and who's the former lead prosecutor on this case, and Jim DeGrotis, that had occurred in 2019. In the otherwise unreported correspondence, Kroll inexplicably used a burner email account with the pseudonym Demetrius Slovaneski and the username of Pied Piper 312. So we covered that yesterday. But as a result of this disclosure, Darrell and them are moving the court to compel disclosure of other information related to this exchange and any similar occurrences between the attorney's office and the potential witnesses. Because yesterday on Twitter, our favorite, I guess he's Chicago Sun-Times, but Jason Meisner, he posted some stuff on there. He posted some stuff, a response from DeGrotis that said, I only sent an email twice. And he says, I sent her the book and I sent her, said I'd love to chat about this. And he never heard back. So, I got up in there and said, wait, hold on. You did hear back from her because the court documents have indicated that you got at least 2 emails from Kroll. So now you're on here lying. You're welcome. Go ahead, y'all. Sit down. I'm doing this. So now you're on here lying. And so this is why Darrell's attorney put in this information, because he said something ain't right here. So it says here, Darrell has moved this court to compel disclosure of other information related to this exchange and any similar occurrences between the U.S. Attorney's Office and any potential witnesses. Says the motion that they put in yesterday is currently pending and awaiting a response from the government. The disclosure of this surreptitious communication between the lead assistant U.S. state's attorney assigned to this case and a potential witness also casts a new light on other communication that may have been recently disclosed to the defense. Specifically, there are additional communications involving Kroll, which after additional scrutiny appear to be equally, if not more troubling than the revelation of this Demetrius Slovaneski. This subterfuge addresses, that they brought up in the motion. Okay. They're saying here, in particular, the discovery contains screen captures of text messages that were exchanged between Kroll and Minor One. Now, it's cool if you're talking to a potential witness. You are the lead prosecutor on the case, so it would seem appropriate that you would be talking to this witness. But somehow, you're not logging these messages. And the nature of the messages is what's problematic. That's where the problems lie. Let me check out the chat real quick. I appreciate y'all for pulling up. Be sure to hit the like button, share, subscribe if you haven't already. Tiffany only says no ethics in this case whatsoever. Ain't that the truth? Yes, they are being exposed. Let me see here. I brought these donuts down here for I brought these donuts down here for them this morning there, Tiffany only, please. Love and life, what's tea? Say, hey, Mel, a lie don't care who tells it as long as it gets told. Ain't that the truth? So they lying real good. I mean, damn, if there was an award for lying, Kroll and them would get it. You heard? So it says, while they were categorized as discussions of scheduling, the general tenor of these messages is extremely familiar and oddly personal in a way that is simply not consistent with the professional standards of the U.S. Attorney's Office. Yeah, because why you would be referring back and forth to a potential witness, important witness at that, and you calling her boss baby, and when it's too much to type, you just call her BB. What's that, BB? What's tea, girl? Yeah, what's going down? Okay. Just call me Demetrius Slovaneski. Come on now. It's totally unprofessional. Now, when combined with Crow's apparent cloak and dagger scheme with Jim DeGrotis, a closer analysis of these text messages, those contents, reveals a number of troubling questions that call for swift answers. And swift is right, because this case starts in 10 days, August 15th. And I personally feel like first of all, they need to just go ahead and drop all this crap and free Kelz and let him out on bond while Bonjean is handling this appeal out of Eastern District of New York. This is out of control. And just as a side note, this motion says, government counsel attempted to explain AUSA Crow's behavior at the pretrial conference in this case on August 3rd. However, subsequent comments from Jim DeGrotis to the Sun-Times and the Chicago Tribune contradict that explanation. Issues related to DeGrotis' comments will be addressed in a reply to the government's response to the initial motion to compel. So it's going to be dropping. It's going to be on fire. Everybody's going to be on. So be sure to check everybody out. Hit everybody's like button and subscribe to everyone. Now, it says these Crow minor one text messages are notable and troubling for multiple reasons. The meetings and calls arranged by Crow and minor one referenced in these text messages do not correspond to any disclosed reports of meetings or interviews with minor ones. You don't have any documentation. You didn't even document that you met with minor one. Number 2, it says AUSA Crow makes reference to needing to contact minor one outside of work hours. For what, Crow? Why? Instead of using the name minor one in her contact list in her phone, AUSA Crow has, without explanation, chosen to identify the most critical witness in this case as Boss Baby. This less than professional nickname is referenced in one of the text messages from AUSA Crow, in which she directly addresses minor one as BB. This unseemly and excessive familiarity and personal nature of the relationship fostered by Crow is specifically exemplified by her receipt of personal photographs of minor one in the form of selfies showing her pregnancy, which AUSA Crow responded. She responded to these pictures very effusively, like, "Oh my God, you're so beautiful," whatever she said. I don't know what she said, but she was full of praise and excitement, complimenting minor one as being beautiful and glowing, and saying that she was very happy and excited for her. And these text messages also indicate that these pregnancy selfies were shared between Crow and Homeland Security investigator agent Monila. So Molina, who apparently also participated in several of the unreported meetings and phone conversations she's referenced in these text messages. So y'all, they just got their own little private team going on. And it's all covert. You doing it all undercover, but yet and still y'all trying to hem Kelz and them up over a memo that was signed with the Van Allen lady allegedly, and then y'all trying to use that and say that they did that so they could miss out or avoid being damn. They're trying to hold that memo against Kelz and them, saying that they use that to try to get out of the truth coming out. That's baloney. But y'all doing this slickness. Come on now. Undue influence of witnesses by government attorneys cannot be tolerated. Excessive familiarity and personal connections between government attorneys and critical witnesses are improperly precisely this communication is improper precisely because such personal connections allow for improper influences on the witnesses that can shape, taint, or skew the testimony they ultimately give. And if you notice, that's the thing they want to do. That don't use the minors' names. Keep them all as a Jane Doe. Don't use the mother's name. Protected jury, secret jury, blah blah blah. Y'all want all this secrecy, and y'all are dealing in secret, but yet y'all got Kelz's sex life all on trial. Y'all got his sex life on trial. That mitigation report was personal. That was personal. And y'all got all of Kelz, the mama and the sister and Lucius and all them. That's personal. And y'all, all that's out there though. But they doing this on the low. According to the text messages between Minor 1 and Crow, Agent Molina was also in personal contact with Minor 1. It was Agent Molina who provided the pregnancy selfie of Minor 1, which was not at all germane to any aspect of the investigation in this case. Molina provided that picture to Crow. According to the text messages disclosed, Molina directly sent multiple pregnancy selfies of Minor 1 and apparently chose her favorite to forward to Crow, who then made a series of effusive comments about it to Minor 1. Like, yeah, girl, Molina sent me that picture of you being pregnant. Girl, this is so cute. Oh, girl, you cuter than Sierra. She didn't say all that. I'm just, filling in some blanks. But words, you know what I'm saying? But this is your behavior. This kind of blatant pandering with a material witness in the case is not only inexplicable and unorthodox, but it creates the plain appearance of impropriety. Now, I'm about to go to the comments real quick. Somebody tell me, do y'all think this is right for a government official who is prosecuting the case of the century? For her to be interacting with an important witness like this? There's supposed to be a standard protocol as a prosecutor to communicate with witnesses. That appears to have been broken in this case. Absolutely, Tiffany, only please. Good morning, Mel Cruz in chat. What's T, lovable Leo? What's up, Tracy? I seen you over there in I think I seen you in Paps and in Texas Black Diamond this morning. Thanks for pulling up over here, and good morning to all y'all. Y'all be sure to like, share, subscribe if you haven't already. But do y'all think this is appropriate? I know y'all don't. If you support Kelz, y'all know this ain't right. And again, if you don't support Kelz, you should at least support fair judicial behavior. Everybody deserves a fair trial. Okay. Aside from the obvious indecorum of referring to Minor 1, the central witness of both the 2002 case and in this instant manner, aside from referring to her as Boss Baby and BB, as well as receiving and commenting on extremely personal photographs of Minor 1, all of which suggests an inappropriate personal relationship that developed either during the time the government was attempting to induce Minor 1 into cooperating, or worse, predating the investigation altogether. So was y'all having all these conversations before Kelz was indicted? Because the conversation between DeGrotis and Crow were before Kelz got indicted. Hold on, y'all. All right, this is the last one, y'all. Be good and be quiet. All right. So you guys, you're staging this. This is not an investigation. This sounds like a creation of a case. All right. Let's see. The most egregious revelation stemming from these text messages is that there were multiple phone calls and at least one in-person meeting between Minor 1, AUSA Crow, and possibly Agent Molina that were not memorialized. They did not document them. They're not an official record. They are as follows: August 21st, 2019, phone call. November 19th, phone call. January 2022, or as you are January 22 of 2020, an in-person meeting. February 24th of 20, a phone call. March 5th of 20, a phone call. June 2nd of 2020, a phone call. June 10th, 2020, a phone call. In addition, unlike text messages that the agents exchanged with other witnesses that were properly memorialized in reports, these text messages and conversations were not. Why? We need y'all to explain that. Drop these charges. Y'all have tainted this whole damn thing. And to me, any evidence that they have gotten out of these undocumented, indecorum interactions, that should be what they call it, a legal term, fruit of the poison tree. They should not be able to use any of that against Kelz. It should not be entered into the hearing. Not at all. Not right at all. They are literally doing whatever they want. Absolutely, Melissa. It's like prosecution is going rogue. No rules apply. And on Monday, this judge needs to put a stop to all this corruption. Funds being removed from the account with no motion or payment plan set up. Absolutely. Absolutely. This case is insane. Let that man go. I mean, they have tainted it. It's dirty. It is dirty. And if you are in the right, you ain't got to do all this. You ain't got to do all this. Standing for injustices. We have a full picture now. This was a rush to judgment, and the government acted on a docuseries. Remember that. Ain't that it? Facts. Ain't that it? Ain't that it? Hold on. All right. So it says the absence of any memoranda or reports regarding these 7 conversations that Darrell and them know of, at least at this point, raises serious Brady versus Maryland concerns, regardless of whether they were never properly memorialized or simply not turned over. The federal rules of criminal procedure requires the government to provide defendants with documents or other tangible objects that are material to the preparation of the defendant's defense. So why they didn't turn that over is suspect. It's sus up and through here. To be material, the discovery sought must significantly help in uncovering admissible evidence, aiding witnesses' preparation, corroborating testimony, or assisting impeachment and rebuttal. And if you notice, that's why the government was strong talking about you can't impeach the witnesses. Because if Darrell's attorney hadn't brought this up, and waited until the trial, could he have said, did you have a phone call with the former lead attorney and Agent Molina on June 2nd of 2020? And that would have blown everything out the water. Okay, they could have came back and asked that, and then the government would have been like, wait, objection, and then all this would have came out, and they probably could have got a good damn mistrial. Probably got a good mistrial. They don't need to go to court on August 15th. And Judge Harry needs to go ahead and say, wait, hold on, we can't do this. Because this needs to be dealt with. And there is no, well, we ain't going to call nobody. But are you using information that you got, one without a warrant, one without disclosing it? You doing some underhanded crap. I hope, and if this does continue to move forward, if this case continues to move forward, I hope the jury is well aware of this, okay? So they can say the same thing. Wait, hold on. If y'all in the right, why y'all doing all this sneakiness? All right. The Brady doctrine applies equally to evidence impeaching the credibility of government witnesses as it does to exculpatory evidence. And remember, they don't ask the defendants about their sexual predisposition. Don't. What? The government is like, don't do this, don't do that. We talked about it in the other videos, y'all. Reports of conversations that would illustrate an inappropriate personal relationship with a witness certainly qualify for disclosure under this Brady Doctrine. And why y'all didn't come up off of it is the $6 million damn question. Let me run to the chat real quick, see what y'all talking about. Let me see. Melissa said facts. Let me see here. Thank God for Darrell's people were able to get this information. I don't know, but I'm thankfully they did expose the government. Hail to the yeah. Too cute in the house. Good morning, too cute. They about to feel that heat from Bongine. You already know. You already know. Let me see. Tevin Johnson. What's up, chat? What's up, Tevin? Thanks for pulling up. Appreciate you. Lysandra Gillard. We all we got, girl. We all we got. Let me see what y'all talking about. All right. Y'all hit the like button, share, subscribe if you haven't already. All right. Now, let's get into this. Minor One's testimony is critical to the government's case. Her credibility is certain to be at issue at trial. The government's entire theory of obstruction of justice stems from, in part, the claim that Minor One lied to a grand jury in 2002. To now have at least 7 undocumented conversations and meetings with this initially reluctant witness is evidence that, at best, there are other facts and other assertions Minor One has relayed to the government that have been kept from the defense, or, at worst, there was some sort of undue influence or coaxing of this witness who never sought out this attention from the government, which was not documented in any way. Neither is acceptable. And remember, on Kelz, what was it? His sentencing. Remember, it came out. Hey, Kelz, I didn't want to do it, but they made me. Huh? So who are we talking about now? Now this is starting to make sense. I'm not saying it was Minor One, but that just adds some context. This disclosure right here, this information right here, seeing that they're doing all this extra talking, is adding some context to the person whose name was not disclosed that said, I didn't want to do it, but they made me. Okay. And if you watch enough of these interrogation videos, you'll see how these detectives will get in there and be friends with you real good and then turn on you on a dime. So did somebody that they had these sneaky conversations with admit to something and then they turned it around and used it against them? This is some BS, y'all. Period. When taken against the backdrop of typical governmental procedures when communicating with witnesses in an investigation, the absence of any documentation of these meetings highlights the impropriety of what the text messages reveal. Even in this case, as an example, the government created reports detailing calls and text messages received by witnesses. Now, just in the interest of time, I ain't going to read every single last one of these, but I'm going to put it like this. Minor 7, Minor 3, Minor 7, Minor 4, Minor 3, Individual D. There were multiple interactions that Kroll and them had with all the names I just mentioned. Minor this, Minor 1, Individual D. They documented those. They put those in a report. Okay? But for some reason with Minor 1, the multiple conversations, the interactions, they ain't document that. So y'all knew what to do, but you just chose not to do it in this particular instance. You're not going to tell me you forgot. Because again, that was the question they said yesterday. Who authorized y'all to finally disclose this information to the prosecution? That's first and foremost. So y'all had a supervisor. Somebody was calling the shots. And who authorized y'all to even have these secret conversations? Who authorized you, Kroll, to use that fake email? So so people are involved in this. And this needs to be disclosed. And to be honest with you, I don't think they can pull out the whole story to anyone's satisfaction and still go to trial as it's set right now on August 15th. I don't see that happening. So Darrell's attorney further says, yet none of the documentation occurred with these conversations between Kroll and Minor One. You documented all these other combos, but with Kroll and Minor One, kept that on the low. What's T? This means that Kroll participated in a clandestine, pseudonymous dialogue with Jim DeGrotis, the journalist whose reporting began the investigation into the Robert Kelly 2002 saga. And she engaged in unreported and apparently secret conversations with the critical witness whose presence on a video and under oath statements about that video created the entire case in 2002. That very case, y'all, that Kelz was acquitted of, okay? And the obstruction justice, oh man. This is breaking news right now. Can y'all believe this? This is out of control. Shout out to Lori Fleming. Absolutely free Kelz. Yeah, go ahead and dismiss this case with prejudice. It's too tainted. And we haven't even heard about the illegal mess of Avenatti and Fox were doing. Absolutely. But y'all still want to get this thing done in 10 days? And then, like the judge said on the phone call, I'm good. I'm known. I got a reputation. For making a trial go fast. Y'all, you signaling that it's going to be a kangaroo court. Shout out to Baby Shay in the house. Unbelievable, y'all. I'm reading it and I'm just getting like, what? Sir Miguel in the house, thanks for pulling up. Appreciate all of y'all for pulling up. Y'all sit down for me. I love y'all. Sit down. Sit down, baby. All right. Ooh. Okay, let me keep this going, y'all. This is blowing my mind. All right. This combination of facts illustrates improper and clandestine handling of witnesses by a government attorney who spoke to and influenced every critical witness in this case. And this makes me wonder, is this why y'all wanted to do New York first? Huh? Why did y'all want to do New York first? I want to know that. Interestingly, both Kroll and Agent Molina are no longer part of this case. As previously indicated, AUSA Kroll was originally the lead prosecutor on this case. She left the case, although did not withdraw as counsel, sometime in 2020 and was transferred to a U.S. Attorney's office in another district. Homeland Security investigator Agent Amila Molina was also a prominent participant in the early stages of the government's investigation. She testified before the grand jury that returned an indictment in this case. She is conspicuously absent from the government's witness list for trial. Y'all, are y'all kidding me? Where they at? If the case is so solid, where are y'all? But the government tried to be on the call. And this team that's on it now, they probably didn't have nothing to do with it. That's why that's what I think. The present team that's running this case against Kelz and NDIL probably didn't have nothing to do with these shenanigans. And that's why the tone in that prosecutor's voice on the phone call was like, I don't worry about it, Judge. We good. We ain't gonna, we good. We ain't even gonna call him. You know, cause if it was me, I'd be like, I would want to say, I didn't do it. It wasn't me. I ain't about that funkiness. But that's not sufficient for legal actions. That's not sufficient just to say, well, we ain't gonna call him till we good. No, we need to know, what did you get out of this poison tree? did this case come to fruition because of Jim DeGrotus? Because he was making up stuff? In sum, these text messages suggest that Kroll and Agent Molina fostered an inappropriate personal relationship with Minor One, who was indisputably one of the central witnesses in this case. Whether this was done with the intention of fostering undue influence over Minor One and her potential testimony is not clear from the face of the text messages, but especially in light of the fact that many of the referenced meetings and telephone conversations were apparently undocumented, the appearance of impropriety is certainly present. Due to the troubling nature of these communications and the previously revealed emails between Kroll and DeGrotus, Durrell asked this court to compel additional discovery regarding the government's communications with witnesses in this case. Durrell requests an order requiring the government to disclose, I believe it's 7 things. I'm going to run through them real quick, y'all. And I appreciate y'all pulling up. All right. This is what Durrell and them are asking the government to come up off of. Any and all text message exchange between Minor One, Angel Kroll, and whether before or after she left the United States Attorney's Office for NDIL. They're also asking for an explanation for the Boss Baby entry into AUSA Kroll's iPhone and when it was input, as well as an explanation for when and why Kroll started referring to a critical witness with such a peculiar and personal nickname, or a shortened form of it, BB. What's TBB? What's going on, Boss Baby? Come on now. Durrell and them also want any and all contacts between Kroll and any other civilian potential witnesses in this case, regardless of whether or not the government intends to call them as witnesses in their case in chief, including any and all text messages, emails, records of phone calls, cell phone and landline, and any other communications she may have had with witnesses under her name, their name, or any other aliases. They also are asking for any and all contacts between Molina, Agent Molina, and Minor One, or any other civilian potential witnesses in this case. It is apparent that there are texts between Molina and Minor One. They are referenced in the Boss Baby text. At the very least, those must be turned over at once. Because again, Molina is the one that testified at the grand jury. Okay? Okay. Durrell and them also want all communications exchanged between Kroll and Molina during this investigation. Yeah, we need to know about that. Because here's one thing I want to know. Was you in there talking about, was there any racial over and undertones in this thing? That's what I want to know. Because why would you call Kelz a Pied Piper? We know Kelz calls himself a Pied Piper, okay? But why are you calling Kelz a Pied Piper? Are you even hip to Kelz music? And how were you referencing Boss Baby? Was y'all joning on her in the background? Yeah, she thinks you're a boss. Blase scoop, blah, blah, blah. Do y'all really care about the minor? Will Minor One and the rest of them find out that y'all really didn't give a damn? It was never about them. It was just about taking a black man down. It was just about breaking the law, calling yourselves upholding the law. Because these actions are not legal. This is not procedure. I'm sorry, I'm raising my voice up in this speech. Okay? I want to be a fly on the wall come Monday. Girl, what you done said. Right, let me see. At the Only Male Cruz, these so-called lawyers are actors. I'm convinced TV lawyers performs better than this. Say it, Love and Life. Wouldn't hire them to walk my dog. Definitely would put my life on the line with them. Girl, what you done said. Ms. Butter, good morning. Thank you for pulling up. Y'all be sure to hit the like button, share, subscribe. If you haven't already, Replay Gang, leave a comment. You know I want to hear from you. Y'all, I'm going to take a page out of Sean Davy Way's book because he always gives good advice. Look, y'all, these streets is going to be hot this weekend behind this case. So check everybody out. And when you go over there, hit their like button and subscribe to the channels. All right? All right. So the above items are necessary to ensure that Darrell has adequate discovery in this case concerning potential improper influence on witnesses against him, and to ensure that he has adequate information to intelligently determine whether any additional motions may be necessary as a result of this clandestine and unprofessional communication and disclosure. Wherefore the court blase scoop de ville, signed Darrell's attorneys. Y'all, this is out of damn control. And it's unbelievable. If this happened on TV, y'all know damn well we would say they wouldn't do that on TV. No. But they're doing it in real life. And let's get into this real quick. Oh, wait, I didn't pull that text up. But we're going to get into this anyway. With our boy, DeGrotis, talking about he only got 2 responses from or he got no response from Krill. But the motion that everybody read yesterday, that I read yesterday, it already says that Kroll reached out to him at 5:33 and 7:07. So DeGrotis might be telling the truth when he says she never emailed me back. Yeah, from her professional email account. But what about Demetrius Slovaneski? How many emails did you get from that one? That's what we'd like to know. And then, and Melissa, you mentioned it earlier too. Bongine was popping off on Twitter yesterday as it relates to the government or the BOP. Once again, accessing how much money Kelz had on his commissary and disclosing that to a reporter. There was no reason for that BOP to be doing that BOP officer to be doing that, but they did. They don't give a damn. It's like this our house. We do how we want to do. That's also why y'all just put Kelz on suicide watch, because y'all felt like it. And nobody is holding them accountable. Shout out to Shrinker Sharon in the house. What's T, girl? Thanks for pulling up, y'all. Okay? So then you turn around and swipe the money in Kelz's commissary, leaving him $500. $500. Like, did you take, what's my girl's name? Jezeline? Y'all take her money? Did y'all take, is this a consistent pattern that y'all do for everybody across the board? Or did y'all single Kelz out? Why did y'all do this? So, oh boy. So my understanding is from that phone call is the government has until Monday. And y'all check this out. On that phone call, the government was like, well, can we get it to you next week, like Thursday or Friday? And if Darrell and them hadn't spoke up and said, I'm sorry, Your Honor, we need this shit sooner than that. They want to get so close to the field goal and then and disclose all that there's not enough time. And there's still not enough time, period. The next motion should be either acquit Kelz or suspend something or whatever. I don't know what the legal term is, but the trial does not need to happen on the 15th. And that should be the next motion that is submitted. And maybe Bongine will put it in, because this needs to be delved into. Are we getting ready to get tainted witnesses on the stand? Real talk. But y'all want to say, but y'all are trying. Kelz talking about he influenced, coerced, enticed, induced. What the hell did y'all do, government? All right, y'all. Give me 1 second. Okay, y'all. If you notice, the Greg kids are still here. So, yeah. All right. So I don't know, y'all. What are y'all thoughts? It's out of control. It's out of control. Be good. Sit down. It's out of control. I want to stay on here with y'all and really chop this up, but I can't see these grandbabies while I'm in here. And I got to keep an eye on them. But this is out of control. I just that's what the next motion needs to be. This case needs to be suspended, or whatever the legal term is. This case does not need to happen on August 15th. And we need some answers from Kroll and them. And, I was looking at some other cases to see, well, what else has Kroll done? She handled another sex case, kind of similar to Kelz, but without the celebrity. And to my understanding, it wasn't a RICO. All her cases need to be looked into, because it wasn't no problem. It wasn't no problem. You didn't have no problem, no threat of, oh, what if they find out? You didn't have no problem operating in a unethical way. So how often have you been doing this? Huh? Is this usual and customary protocol for you, Kroll and Molina? How many other grand jury hearings have you testified at, Agent Molina? And that got people jammed up and got them behind the 8 ball, having to pay legal fees and fines and things of that nature, because y'all just doing what the hell y'all want to do? Damn. So for everybody that says, no, Kelz got what he deserved, listen, they have not been able to prove this shit the right way. If Kelz was guilty and they brought all this to trial, they wouldn't need to do all this. And again, everybody should be in an uproar that any government official would do some things like this and ruin people's lives. That's what y'all need to be mad at. The fact that the government has gone rogue and bringing cases and doing whatever the hell they want. And as long as we don't like whoever it is they bringing up, well, that's cool. Y'all can break the law. But no, that ain't right. Y'all gonna bring me up for breaking the law while y'all break the law to prove I'm breaking the law, and I ain't even broke the damn law. This is enough to make somebody break the damn law, though. Okay? Whew. All right, y'all. Let me go see about these babies. Let me see what's going on. I appreciate every single last one of you for pulling up and participating. Hit the like button. Subscribe if you haven't already. Replay gang, you know what time it is. Leave a comment, because you know I want to hear from you. And until next time, y'all, we will see ya when we see you. Welcome to the Only Male Cruz Show, the podcast. I am the Only Male Cruz. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work.